Welcome to another edition of Regulatory Ramblings Briefs. Our topic today is an article that appeared in the Stanford Journal of Blockchain Law and Policy entitled Smart Courts, Smart Contracts, and the Future of Online Dispute Resolution. The authors are Dr. Julien Chaisse, who's a professor of law at the City University of Hong Kong and the co-founder of the Internet Intellectual Property Institute, and Dr. Jamieson Kirkwood, a post-doctoral fellow with the Faculty of Law at HKU. Jamieson, thank you for joining us.
Thank you.
So, your article offers a, quote, critical assessment of the online dispute resolution process, particularly in its evolved form involving smart contracts and smart courts, which is a mechanism that you say that China may consider for settling its Belt and Road Initiative disputes. What prompted you to write the article? What prompted you to bring those two concepts together, BRI and online dispute resolution?
Right. Well, when I was doing the research for my PhD at Chinese University of Hong Kong before I came here, I can see the mismatch between what I call legal uncertainty in the BRI, where there's over 100 countries, different legal systems, and there's so much inconsistency in the awards. It's an unfortunate mix of, say, legal strategy, forum shopping, and power politics in the case of smaller projects or smaller countries. And then juxtaposed to that is China being one of the global leaders in technology. In 2015, they started building the digital Silk Road. In 2016, they had various informatization strategies, which effectively brought a smart court system into China, where they established China Judgments Online and other forums to make the court system in China online 24/7. Also, in 2017, China established the world's first internet court in Hangzhou.
Yeah.
So there's clearly a mismatch between the technological prowess of China and the kind of legal uncertainty in the BRI.
That's a fair point, and the ongoing docket, the court never sleeps in a sense. Now, in your article, you say that yours is the first article, quote, to address the emerging dispute resolution settlement technologies in the BRI context. It suggests guidance for policymakers and practitioners. Could you flesh out what you mean by guidance in this context? I mean, what is it that you're recommending?
Well, in the article, we actually suggest a smart court system to be implemented in the BRI. Now, we outline
with standard rules across the board.
Two versions. Yeah. So one is a lighter version, and the second one is a more complete version. The lighter version would be basically things operate as they are now, but the smart court would be there to kind of track the cases and make the communication between the parties and the courts more transparent. The more complete version would involve an actual registration of all BRI projects and BRI project disputes. And then whenever a dispute occurs, it would be facilitated by the smart court and potentially adjudicated, or at least there could be suggestions for adjudication made by the robo-advisors in the smart court system.
Interesting. Then you think about the opt-in mechanism, and I guess people are wondering then, by virtue of joining the BRI, is it a given that you're accepting these rules for dispute resolution?
Well, that's an interesting point, and
conceivably could it get to that point? The kind of like with joining the EU, their rights and their responsibilities and obligations.
Well, the BRI has a long way to go to get such a sophisticated system like the EU. I mean, there is no BRI treaty.
Correct. So it's more ad hoc. It's more bilateral.
But in the case of like a complete smart card system, there could be a registration of projects. So then everybody would know, okay, this is a BRI project, and it will be adjudicated in the smart card system, and the awards will be enforceable, because that's the rules of kind of registering your project.
You know what you're getting into up front then. Your paper also poses, quote, the key question of whether ODR can result in more convenient and efficient processing of BRI disputes, and hence be assimilated into potentially fill some of the gaps of the current BRI dispute settlement system. Could you elaborate?
Well, as I've said, there's legal uncertainty in the resolution of BRI disputes. I'll give some examples. Approximately 2/3 of the 140 BRI countries, if you go on cooperation agreements with China for the BRI, approximately 2/3 of these countries have a kind of an investment treaty with China.
That's right.
But 1/3 of them don't. So therefore, 1/3 would automatically have different investment protections than the other 2/3. That's only a small example, but there's many other examples I can give, such as not every member of the BRI is a member of the World Trade Organization. You know, the countries have different sizes. Some are smaller, some are bigger, etc. So introducing a smart code system can bring more consistency to the way that the disputes are handled and more transparency.
Okay. Your article looks at ODR plus in China, the UAE, and other states involved in the BRE. What are your impressions of the efficacy of ODR plus in these different jurisdictions? Because for my reading of it, it seemed like a mixed bag. That was at least the impression I took away.
Right. As a researcher, I don't have too much first-hand experience of the efficacy of IT in courts across the world. Yeah. However, what I wanted to say is that clearly China does not have a monopoly. There are good systems in other countries like the UAE, like Kazakhstan, other countries, several of which are mentioned in the paper. So the BRI Smart Court does not have to be modelled on what China's doing. It can be modelled on what other countries are doing.
Fair point. Do you see any, because we are talking about smart contracts, do you see any security or integrity issues? I mean, because when you're dealing with smart contracts, they're electronic. There's a technical side to it. Do you see any security or integrity issues?
Well, of course there are issues with smart contracts. That's a developing area. Right. But these issues are nothing to do with the BRI. They're to do with smart contracts.
The medium itself.
The medium itself. As they develop, and they are particularly good for the BRI in terms of like financial contracts, contracts to do with manufacturing, logistics, these kind of things. So as they improve with automated inbuilt dispute mechanisms inside the contract, it can definitely be a medium that the BRI could look to.
Okay. And something you alluded to earlier, as with any dispute resolution system, people want to know what is the conclusion. What's the end game. So that comes to the point of enforceability of decisions, especially with new BRI members. I guess what is the mechanism that compels enforceability then in this context?
Right. Well, there's a couple of things to say. Firstly, enforceability in the BRI is a problem, and it doesn't matter if it's a new country or an old country. As said, there's legal uncertainty in the BRI. So this smart code system can actually be an improvement upon the legal uncertainty we currently have. In terms of enforceability, you're right, there would need to be some kind of mechanism of enforcement. I've given the example in the paper of, say, there could be a convention on judgments made via smart court mechanisms, the same way there's the New York Convention on Arbitration or the Singapore Convention on mediation. The last point to say is that if there's registration of BRI projects and registration of BRI disputes, there can automatically be agreement to comply with the judgments when you register your project.
Okay. When you look at, again, the full swath of the BRI countries, and as I think you pointed out, different levels of development, different legal systems, different levels of sophistication commercially and in terms of regulatory policy. There are turf wars in this region, and that affects data transfer issues. Could you see those types of data transfer restrictions as being an impediment towards the wide scale adoption of such smart contracts across the BRI?
Thank you. Similar to the enforcement answer, so there would be procedural rules for the operation of smart courts. Ideally, there could be a treaty or a registration system for countries to operate within the framework of a smart court system. So therefore, data transfer would be, controlled by the procedural rules of the smart court rules.
Okay. When one thinks about online dispute settlement, ODR isn't completely new in that domain name disputes can be settled online. So I guess the question is what's new and better and improved about the framework you advocate in your paper?
Right. The difference with what we are advocating is that every kind of dispute can be adjudicated, not just domain names. Domain name disputes were popular 20 years ago or whenever it was. But in the BRI, we're talking about, financial disputes, infrastructure-related disputes.
Stakes are a lot higher.
Yeah, stakes are a lot higher.
Is there anything else regarding your paper that we should know that you'd like to highlight?
Only like to mention perhaps about the China International Commercial Court, which was established in 2018, which does to some extent operate as a one-stop shop for BRI disputes. However, it's very different from what we are advocating, because the Chinese International Commercial Court has Chinese jurisdiction, and its judges are ultimately members of the SPC, Supreme People's Court. And in the Smart Court, it has kind of a neutral jurisdiction and would operate via kind of robo-judges.
Intriguing. And frankly, that might be preferable to many people rather than having Chinese a matter adjudicated by, Chinese by a Chinese tribunal in the mainland. Flesh that out. I mean, robo judges. So smart, advanced algorithms deciding matters online. Is that a simplified way?
Potentially, that would be the way to go. At the basic level, it would kind of suggest the avenues to resolve the dispute. But then if we're getting into deeper levels, it can be oracles. And oracles are independent experts who feed information into the smart contract. And then the robo judge would kind of, or the smart contract essentially would continue, because it needs an input from somebody. Once it has the input, it can continue with its automatic adjudication. So the robot judges might not actually be adjudicating, they might just be operating.
Okay. Yeah, that's a distinction worth pointing out, that one would have to envisage multiple scenarios and write that into the code, contingency plans, if this, then that, to again envisage multiple likely problems that might arise.
Definitely, we are not there yet, and coding has a long way to go, and smart contracts have a long way to go to be able to cater for all of these eventualities and get the wishes of the parties into the contracts, and to deal with things such as flexibility, uncertainty, different terminology from different countries. There are many other issues with smart contracts at the moment, so I'm not saying they are perfect. They're certainly not, but they do offer, perhaps a greater, degree of autonomy and potentially fairness from what exists at the moment.
Certainly, we shouldn't just perhaps look at them as digitized versions of physical real-world contracts, that there's more fluidity in terms of the parties determining the metes and bounds, the terms and the parameters of the contract.
Yes, correct.
Yeah. Well, Jamieson Kirkwood, thank you so much for joining us.
Thank you.